Hello to all. Thank you for joining us today for our webinar, Wage and Hour Masterpieces You Do Not Want to Miss. My name is Mary Krakow, and I am one of the employment and labor attorneys here at Fredrikson and Byron. And I am joined today by Ingrid Culp and Eli Best, also from the Employment and Labor Group, and you will hear from each of them shortly. Now, you should have received a link to our PowerPoint, so let's turn there as we begin. As noted in our introduction, wage and hour compliance is ever more important. Employers who get it wrong end up with an expensive bill as a result. Of course, because what is wage and hour? Well, back pay and overtime, and when claims are made, employers can be required under certain circumstances to pay double the amount of unpaid back pay and overtime. And of course, they pay their own attorney's fees, and they end up paying the employee's attorney's fees today as well. Now, our plan for today had been to follow our PowerPoint and then to do your questions, but that plan necessarily has changed. As you can see, the first issue in our PowerPoint was the new federal salary requirements for exempt employees, which were scheduled to take effect on December 1st, the day after tomorrow. But as you likely have heard, a Texas federal district court judge issued an order on Tuesday, November 22nd, so just a week ago today, for a nationwide preliminary injunction putting these new salary requirements on hold for the time being. In other words, the judge stopped the Federal Department of Labor from implementing the regulations or enforcing the new regulations for now. What does that mean for us today? Well, it means our new plan for today is to cover how that injunction came about, and the question we're receiving from our clients, which is, okay, so now what do we do? And as we do that, we want your questions right away. Please don't wait until the end of the hour to send them, because we think your questions will be a great way to address what has happened and what to do now to move forward. And I'm not very good on this technology stuff, but I understand you can hover towards the top of the page, and then you'll get a drop-down box, and there will be a Q&A box there. And if you click on that, you should be able to type in your question, and we'll receive it, and we will try to address it. You're also welcome to ask questions about the actual regulations, and we're glad to address those too. All right, and if we finish all of that, we will take the remainder of our time today to cover the final several slides on other hot wage and hour topics on which we also as attorneys frequently receive questions from our clients. So, leaving this one slide up for the time being, I'm going to turn it over to my colleague Eli and have him pick it up from, okay, so how did we get to where we are today?
Sounds great. Thank you, Mary. Hello, everybody. This is Eli Best. So as Mary indicated, and as you all had probably already heard, just last week, sort of at the 11th hour, a federal district court judge in Texas put the brakes on the new salary requirements that were scheduled to take effect the day after tomorrow. This came about by virtue of two lawsuits that were filed in September. One of the lawsuits was filed by a group of 21 states. The other lawsuit was filed by about 50 business groups, including the U.S. Chamber of Commerce. Both of the lawsuits claimed that by increasing the salary requirement so dramatically, the DOL exceeded its authority. The source of this authority, it comes from the Fair Labor Standards Act. The FLSA has a provision that, as you know, has an exemption from overtime for employees who are in a bona fide executive, administrative, or professional role. And the statute says that those terms can be defined and delimited from time to time by the Department of Labor. And the Department of Labor over the years has done just that. It's defined those terms. It's set forth a duties test And in addition to a duties test, the Department of Labor has always had a salary requirement for an employee to qualify for the white collar exemptions. But for several decades, no one has been so concerned with that salary requirement. As a practical matter, it's always been low enough that it didn't present much of an issue. And that all changed when the department sought to double it to over 47,000, which would have been effective on December 1. So the two lawsuits move forward, and given the impending effective date, the state sought this emergency relief, which is called a preliminary injunction. That's a procedure that parties can use to preserve the status quo while litigation goes forward. If they can prove that they're likely to win and that they're likely to suffer significant harm in the meantime, a court can effectively push pause until a final decision is reached. Their main argument, as I said, was that the DOL exceeded its authority, that the statute allows the DOL to define the duties, but that by changing the salary requirement so dramatically, the DOL essentially put that by itself and eliminated the duties test. At this stage, the court agreed. That's the big news that came out last week. The court said that the states and the business groups are likely to prevail, that the DOL did exceed its authority, and that these regulations are likely to be invalid. So as Mary said, for the time being, the result is that the department is prohibited from implementing and enforcing the new rules pending a final decision. The DOL has the option to appeal right now, but it hasn't indicated that it's going to, and given that December 1st is the day after tomorrow, it seems extremely unlikely that any appeal would take place before December 1. And it's also unlikely that the trial court is going to change its mind when it reaches its final decision, given the strength of the opinion that it issued. So once the litigation arrives at a final decision, the DOL could appeal then, meaning that the Fifth Circuit Court of Appeals could possibly overturn this, though that's somewhat unlikely because the Fifth Circuit is a relatively conservative court. And then the Supreme Court would also hypothetically have an opportunity to overturn this, which is perhaps somewhat unlikely but difficult to predict. And unfortunately, a theme of this talk is going to be that we are in a time of great uncertainty. Another ingredient that adds to the uncertainty is that there's a changing administration, and it's even possible that the new administration would stop defending this new rule, which would lower the likelihood of a reversal on appeal. So with that, I'm going to pass it over to Ingrid to explain just how you can all navigate this uncertainty.
Sounds good. Thank you very much, Mary and Eli. This is Ingrid Culp, and welcome everybody. It's great to be with you today. So I'm going to step back for just a moment and make sure we're all on the same page with regard to what employers have been doing for the last 6 or 7 months to prepare for this new law that we thought was going into effect on December 1st. So as you all are aware, historically, for one of the white-collar exemptions to have applied, an employee needs to have met a 2-part test. They have to have certain required job duties as set forth by the U.S. Department of Labor with some excruciating detail to those job duties tests. And they have to have been paid a salary on a salary basis, not hourly, of at least $455 per week, which was annualized to a little bit more than $23,000 per year. If this new law had gone into effect on December 1, to meet the salary component of that 2-part test, employers would have needed to take their exempt employees and make sure that their base salary was no less than $913 per week, which is annualized to roughly $47,500 per year. There was no change to the job duties tests, so this was really just about the required salary to maintain exempt status. So employers, since late spring, early summer of 2016, have been preparing for this new rule and essentially doing one of two things. if they have an exempt employee who's made less than an annualized salary of $47,500, they have had a decision to make, and that is whether to increase the salary to that $913 a week, $47,500 per year to maintain their exempt status, or to say, nope, we're not going to do that. We're not going to pay the new required minimum salary, so we are going to convert this employee to a non-exempt employee. And that means that they'll, of course, have to record their hours worked, and if they work more than 40 hours in a work week, be paid overtime, time and a half for any hours over 40. So that's been the basic exercise that most employers have been engaged in the last several months. So now what to do? I think the now what to do has a lot of components and factors that play into it, and I think there are kind of two main buckets. The first would be employees who have not been notified yet of any change that the employer planned to make. So if you are one of those employers here with us today who had planned to raise employees' salaries to maintain exempt status, or planned to convert some of your currently exempt employees to non-exempt, but you hadn't yet communicated that to any of your employees, you probably are going to have an easier go of it with regard to next steps. And essentially, your options for next steps would be to either proceed as you have planned to do, even though you are now under no legal obligation to do so. Maybe you think it's the right thing to do. Maybe you have decided in your analysis that your employees are underpaid vis-a-vis the market or the industry, or maybe for whatever reason you still want to proceed as planned. That, of course, would be just fine and legally compliant while not legally required. Or you could decide to press pause as well and do nothing at this time. Since you haven't notified employees, you would not proceed with any notification. You would make no changes, and you would just keep the status quo in place with regard to your current exempt and non-exempt qualification. The only caveat to that, which I think is important to mention today, there are lots of employers who in the last several months did a thorough internal audit of exempt and non-exempt classification. And in addition to recognizing that some salaries may need to be raised to maintain exempt status, some employers have discovered that, separate and apart from the salary, that some of your currently exempt employees probably don't qualify for exempt status because they don't have the required job duties. If you are one of those employers in that camp and you have exempt employees today who you don't believe have the required job duties for exempt status, you still have a problem. You still have an issue, and we would recommend that you proceed with reclassifying those employees to non-exempt, because that was required historically and is still required today, despite the court order. Okay, so that's the first bucket, employers who have not talked with their employees about upcoming changes. The second bucket is employers who have notified employees about a change that was going to go into effect on December 1, or maybe you put it into effect even before December 1. And the basic communications would have fallen into one of two buckets. Either, hey employee, guess what? You're going to get a pay raise on December 1st. Your salary, which is now currently under $47,500 annualized a year, is going to go up to at least $47,500 annualized per year. Great news, you get a pay raise. That would have been one form of communication. Or you may have said to some of your employees who are currently exempt, hey, guess what? You've been exempt historically, but now effective December 1, we are converting you to non-exempt. And then you probably, hopefully, would have explained what that meant. You'll be required to track your hours worked. If you ever work overtime, you'll be paid overtime. So with regard to those employers who have made the communications already, the two big picture options are, again, proceed as planned. Keep in place what you've already communicated and move forward as if this law did take effect and as if the court ruling hadn't happened. To do so would be entirely, again, legally compliant, but not legally required. Or you could roll back what you've communicated. You could now go to your employees and say, hey, employees, we communicated XYZ to you, but there's been a court order that has pressed pause on those requirements, so we are no longer required to do what we communicated to you, and so we are going to not raise your salary or not convert you to non-exempt status. So those are the two big picture options. In my mind, there are several factors to consider with either going forward as planned or rolling back what's already been communicated. First, expense. Of course, if you go forward as planned and you're not required to do so, you're going to have additional payroll expense, increased salaries and or increased overtime for people who you've converted to non-exempt status. I've heard from some clients that their employees who were exempt and have been told they are now going to become non-exempt, some of those employees are happy about that because they're excited they're going to get the overtime pay, and some employees are really upset because there's a certain status that goes along with exempt status, and they don't want to be non-exempt. They don't want to punch a clock. So there's certainly a lot of employee morale issues surrounding these decisions. And perhaps you could go back to those employees who were upset they're going to be non-exempt and say, hey, good news. You get to remain exempt for now. Likewise, for those employees getting a raise, they're probably happy about that raise. And to go to them now and say, oh, guess what? Never mind. We're pulling back that raise. Certainly brings with it, I think, a lot of employee morale issues. I think there's also something to be said for, again, in the employee morale bucket, kind of some culture, workplace culture components. For example, is it important to your company to keep your word, to communicate that you are fair and once you say something, you do it? Would rolling back the decisions that you've already implemented and communicated cause confusion that you'd prefer to avoid? Would rolling back the decisions you've already made, have we already flagged to those employees that there may be an issue with regard to their exempt or non-exempt status, or perhaps flagged that in the eyes of many they are underpaid for exempt status? And then finally, do you have employees who've relied on their pay raise? Hopefully not at this early date, but did they buy a car? Did they buy a house? Have they relied on their pay raise? And what would be the implications to rolling that back? Let me just finally mention, if you have put any of the changes into effect, the pay raise or other changes into effect, and you do decide you want to roll it back and undo it, it cannot be on a retroactive basis. So if you notify the employees, hey, we've already implemented your pay raise, but we're now going to take that away from you, it can't be retroactive. It can only be implemented on a go-forward basis as of the date of notification or beyond.
Okay, well, Ingrid, thank you for all of that great and helpful information. You covered a lot there. And we are getting some great questions, and please, everybody who's on the line, keep your questions coming. These will be important. Here's a question that gets right to the meat of, okay, now what do we do? It goes to, Ingrid, you had said the employers have done now an audit, both as to salary, the new salary, and new salary requirement that we thought was going to go into place day after tomorrow, and then also a duties audit, which that was the right thing to do. So, but now let's address the hard question. Okay, so the new salary has gone away, but the employer learned through its review that, oops, we got a few people that we had classified as exempt, but when we did this review in the last several weeks or months, we figured out, no, they don't really meet any of the white collar duties tests, so they need to be paid as non-exempt. And we've communicated that to employees that we're changing them to non-exempt based on the new regulations. But employees read the newspaper or get the news too. And I even had one client who told me, Mary, our employees are sending us articles about the injunction and want to know what's going to happen now. So they're on top of this. Okay, so how does an employer address the question about the reclassification to non-exempt that we're going to leave in place because we know we need to because of the duties review? They don't perform exempt duties. They perform non-exempt duties. We need to leave the non-exempt classification in place. How do we do that, and how do we message, what do we say to the employees to avoid the employees immediately thinking, oh, I must be due some back overtime? What do we do there? And you two think about that for a minute. I have been reading this question as Ingrid was talking before, so I'll give you a couple of thoughts. The first and foremost is this. The same risk exists now as would have existed at any time, that you did a review of your pay practices and figured out we have some people we've been paying as exempt, and whoops, over time or whatever happened, they really don't have exempt duties and they need to be paid as non-exempt. So we need to correct that. We know we do under the wage and hour requirements. So we're going to, you made a change, or you've communicated that change to the employees. The same risks exist as it always did. But now you've got to help employees understand that we've made a change, and hopefully not immediately think, oh, well, I've been paid wrong all this time. And keep in mind that the statute of limitations for wage claims is generally 2 years, only 3 years if the employees could show you willfully failed to pay as non-exempt when you should have. So one of the pieces of the message I think that you can give to employees is, we have done our review in good faith based on our belief that these new regulations were going to take effect December 1, and we were even ahead of the curve and got all of our review done and implemented our changes. And what we understand is that this is a preliminary injunction, right, Eli? It's
right.
Preliminary.
Right.
And this case is not finished. This case will continue to move forward, and it is possible a contrary decision will be made ultimately. And so we are not going to make another change now. We have done our full review. We made the changes that we believed were necessary under the new regulations that were to take effect. Yes, there's been a pause put on the new regulations, but the case isn't finished. So we're going to stick now with what we decided and move forward. Other thoughts?
And this is Ingrid. I think that makes a lot of sense, and I think it raises a important point about, again, another factor to be considered on what employers are going to do if they have already communicated the change. We are in limbo land. So if you've already communicated a change, and now you're going to communicate that you're rolling that back, will you put yourself in a position that in a month or two from now, you'll yet again need to communicate another communication to employees saying, oh, guess what? We're back to where we were in November. And again, what sort of kind of confusion and perhaps distrust and other things might go along with that. But I think Mary's proposal is a very good one.
Okay. And then let me ask you a question, Eli, on this one. Kind of goes right along with the first question. So how long is the injunction going to be in effect, this preliminary injunction?
Well, it's a little hard to predict how quickly litigation will proceed, but the group of states, that's the plaintiffs in one of the lawsuits, they sought this injunction and they received it. The businesses took a different strategy. They have already filed a motion for summary judgment, which is already fully briefed. And now I'm not sure if a hearing has been scheduled. There was a hearing scheduled for today, but the court canceled it because it was no longer so important to get that hearing done before December 1st, since the injunction was granted. But in all likelihood, at some time within the next, say, 2 to 3 months, there will be a summary judgment hearing, and given the court's position on the injunction motion, a reasonable guess is that the court is going to grant summary judgment for the businesses, which would then become a final order that could be appealed.
And just to make sure everybody understands, what does it mean if summary judgment is issued?
If summary judgment is issued, that would mean that these regulations are declared invalid, struck down, and not on the books unless there's an appeal and a reversal.
An appeal up to, you mentioned the Fifth Circuit before. Would the Fifth Circuit would they have to receive the appeal first and decide it before it could go to the U.S. Supreme Court, or could it jump to the U.S. Supreme Court, if you know?
In all likelihood, it would go to the Fifth Circuit first. That's
Okay.
the normal course.
Okay.
And I think Eli mentioned this earlier, but I think the change of our president is really meaningful in what the future might look like. If I had to predict, and I'm not our procedural expert here today, Eli is, but let's say that President Obama was remaining in office, or perhaps Hillary Clinton had won the election. Even if the courts continued to rule in the states and the businesses' favor by saying, no, this is an ineffective rule, I think the U.S. Department of Labor and President Obama or President Clinton would have likely continued to really press this issue hard. Maybe different regulations, maybe in a different context or venue. But with President Trump coming into office, and again, it's hard to predict what his positions will be, but I think there's a less likelihood that he and the new U.S. Department of Labor under his govern will push for either these regulations or some new regulation to be adopted. I don't know, Eli, if you have additional comments on that.
That does seem like a pretty reasonable prediction. One little tidbit, though, an interesting point, just to make clear that this isn't always a political question. The district court judge in Texas who issued this injunction was actually appointed by President Obama. So that might come as a little bit of a surprise to people who are trying to guess how these things were going to come out, but it's not always a matter of liberal versus conservative.
Yeah, and the one thing I would mention here, just because I heard it driving in to work this morning, it's happening here in Minneapolis, and I understand it's happening in cities across the U.S. today. A concerted effort by groups who want the minimum wage to be set at $15 an hour, and they're protesting and marching today at various places. And, that movement's been going on now for several years, and of course we don't have $15 an hour even here in Minnesota. Our minimum wage for non-exempt employees for most is $9.50. But I mention that only because, Eli, what you just said, which is, it's not always a political thing. It can be a grassroots thing. And if that $15 an hour movement, grassroots movement, continues to grow and receive more mileage, if you will, it may be that people who are paid a salary and the salary is back then to the $23,660, $455 a week, as Ingrid mentioned, might wake up and start marching too, because they got a taste of what could have been $47,500, to round the number, a year, and to think that now they have to only be entitled under law to 23,660, I mean, we just don't know. And we can't predict by any means. The predictions I've made in the recent past have all been wrong, so I'm not making any predictions there. So we'll all have to just wait and see. And I think Ingrid's point that we are kind of in limbo here, we're in uncharted waters, is really true. But please do keep your questions coming. I've got a couple more here that I think are important, and hopefully others are thinking of these things too. All right, so if we don't move forward with the 47,500 required for exempt employees that we believe absolutely have exempt duties, but we were planning to raise their salary to what was going to be the required level, $913 a week, we don't do it. And the case moves forward and in effect is reversed so that the regulations are in effect by law. Okay, so we didn't do it December 1. What's the likelihood of penalty for non-compliance back to December 1? Anybody? Eli? Ingrid?
I hate to hammer on the constant theme of unpredictability, but it's a risk that can't be ignored.
Okay.
Courts across the country aren't entirely consistent on this issue. This is a very technical issue about retroactivity, but it is possible that a future court would decide if the regulations are put back on the books by an appellate reversal that it goes all the way back to December 1st, and it's as if they had never had this period of invalidity. So that's definitely a calculated risk that employers need to consider, the possibility that the regulations would be struck down, then brought back to life, and treated as if they had never been struck down in the first place.
And then with the ruling or whatever is decided, they could put as part of that it's retroactive to December 1, and employers may get a certain period of time to make up the difference of what they should have paid as opposed to what they did pay.
I think that's right.
Ingrid?
Yeah. I mean, my reaction, and this is just me in my own little world, but I think retroactive application would be really unfair. So my strong hope would be, if this rule is put back on the books, that employers would have some fair notice. I don't think it'd be as long of a notice period as we had over the last 6 or 7 months, but some fair notice without retroactive application. But again, that's just my hope and wish.
Yeah, and I would go along with that. It seems unfair now that they've taken it off the book, so to speak, to make it then retroactively apply. My thought too, though, was if they did retroactively apply the salary requirement, hopefully they would not impose penalties for failure to pay that salary during the period of this uncharted water. We don't know what's happening.
The other thing that could happen if it was retroactively applied is, legally speaking, retroactive application would be required, but practically speaking, the Department of Labor could choose not to enforce that piece.
Right. But of course, then there's always a risk under wage claims, which is the Department of Labor can bring the wage claim, but so can individual employees. And even now, I have heard speculation, and that's all it is, it's just speculation. What if an employee chooses to seek enforcement of the 47.5, even though the Department of Labor is enjoined from enforcing it? And, that would have to be an employee, goes to a lawyer, gets a lawyer to represent the employee to take the case to say, I want 47,500 a year, the $913 a week. That's possible, but how likely it is, I think, is a whole different question. So, Eli, Ingrid, want to comment on that?
Well, I think that if that lawsuit arose, I think that the employer would have a relatively solid ground to stand on in light of this injunction that prevents DOL from implementing the regulation. Maybe it's not as clear as it could be, but the argument would be this regulation right now does not exist. You have no grounds for this claim.
Yeah.
And we could feel pretty good about that argument.
And probably it wouldn't go very far.
Right.
Right. Well, very good. Okay, I have one more question on the salary requirements. One question that's come in, but if you have others, please do send them. Here was the question. What concerns do businesses have with the potential new rules? That the rule, I think this question is going to the requirements for the salary that have now been put on hold, and what were the concerns of businesses? Ingrid, you want to take that?
I think the primary concern of the business was just the expense and the impact to their bottom line and their overall payroll expenses. The employers that I've heard from the most who have been most upset about the new December 1 law have been two, nonprofits and small companies, particularly in rural communities, but certainly some small ma and pa shops in metropolitan communities as well, who have not paid their exempt employees a salary of $47,500 and were looking at and needing to make major pay increases to their salaried employees to keep them exempt, or the cost associated with taking some exempt employees and converting them to non-exempt and facing the associated payroll costs with overtime pay if those non-exempt employees worked more than 40 hours a week. So I really think this is about dollars and cents and what some employers were going to experience in additional costs to simply pay and employ their employees in a legally compliant manner.
Right. And it was a cost thing, and as I heard various clients say who received maybe all or much of their funding via the federal government because of the kind of services they provide, it was a mandate without any funding, and that really put them into a financial bind.
Mm-hmm.
Yeah. All right. Well, any more questions on the salary requirements for exempt employees and what all that means? Please send them. But we did get at least one question off that topic, so I'm going to go to that one now, and then we'll pick up with in the outline, in the PowerPoint, if you scroll way ahead to section Roman numeral 2, we'll pick up with meal breaks and other breaks in just a minute. But I'll answer this question first. Are there any changes to holiday pay, vacation, or sick, or PTO, and are any of these required now by federal or state law? Well, I don't know of any changes or requirements for any company under federal or state law to pay holiday pay or vacation or even paid time off, the PTO type arrangement. The one thing, though, that we do know is both Minneapolis, the cities of Minneapolis and St. Paul now have passed and enacted ordinances that require sick time. Paid sick time for the most part, but then sick time for really small companies. They still have to implement a sick time and safe leave policy, but it might not have to be paid. Now that's a whole nother topic for another webinar or seminar that we may be able to do before July 1 when both of those laws take effect. But if you have employees in the performing services in the city of Minneapolis or within the city limits of St. Paul, you need to be aware of those ordinances and begin planning now, I think, for implementation.
And I'll just mention a couple things. There are many cities across the country and several states outside of Minnesota that have adopted their own paid sick leave laws. So if you have employees around the country, various cities, various states, I would recommend that you review, and we could certainly help you with this, what the status is in other cities and other states, because this seems to be quite a trend, these paid sick leave laws, and they're popping up regularly throughout the country.
Yeah, absolutely. Okay, Eli, can we ask you to pick up with breaks?
Sure, absolutely. Everyone's probably been focused almost exclusively on overtime for the last several months, but it's always good to get a refresher on the other laws that aren't quite as controversial and aren't doing complete 180-degree turns every time you look at them. We've been talking mostly about federal law so far, but breaks are one area where you need to be aware of both federal and state law. And just a general point, whether it's overtime or breaks or anything else, you always want to be sure that you're complying with the more generous of federal or state law. You need to give your employees whichever law gives the employee the most protection. The general theme on breaks is that federal law doesn't require that any particular breaks be provided, but it does have specific laws regarding whether you can treat a break as unpaid. And those rules about paid versus unpaid time, that applies only to your non-exempt employees. You're never going to deduct from an exempt employee's pay because they took a 30-minute lunch break. But as I'll explain, you could treat a lunch break as unpaid for a non-exempt employee. Continuing on the general theme, state law, Minnesota law, does actually have some specific requirements about what breaks need to be provided and how long they need to be. The first main type of break are meal breaks. And as I said, the federal law, Fair Labor Standards Act, does not require that any break be provided. But if you do give a meal break and you want to treat it as unpaid, there are specific rules you have to follow. First, the break needs to be at least 30 minutes long. And second, the employee needs to be relieved of all duty. And that's a little bit of a tricky one because duty can be active or inactive. You might tell an employee, you go take your break in the lunchroom, but there's a phone there, and if that phone rings, answer it. That counts as inactive duty, and the break would need to be paid. And another thing to keep in mind is that if an employee does any work during the break, even if it's just 10 seconds of work, the entire break needs to be paid. So the general idea is you need to be very cautious. If you want to treat a break as unpaid, make sure there's a very clear demarcation. No work is performed. There's no expectation of work being performed. That being said, you are allowed to have your employees remain on the premises. But if they're on the premises, a little risk creeps in that there's going to be some duties for them to perform. So just be cautious. Turning to Minnesota law, as I stated, there is a specific requirement. If an employee works 8 hours or longer, you must give them a break that's at least 30 minutes. The law says sufficient time to eat a meal. In practice, this means at least 30 minutes. And then there are the same rules as under federal law regarding whether you can treat that break as unpaid.
And Eli, can I jump in and just give my plug for why I don't like auto deduct?
Sure, absolutely.
for meal
Oh,
breaks.
yeah.
So there are some employers around the country, perhaps even some of our own clients on the webinar today, who use a practice for meal breaks called auto deduct. So they say to their non-exempt hourly employees, hey, you get a, say, 30-minute or hour lunch break, whatever it is. It's unpaid, and you need to take it, but we're not going to have you punch out and punch back in to record the actual break that you took. We are just going to assume that you take the required break, and we are going to automatically deduct from your hours worked whatever the required break period is. It's called auto deduct. But there's no actual time record or time reconciliation against the actual break that was taken. Technically, the Department of Labor has said that auto deduct is permissible if the employee actually gets their full duty-free break for the amount that was auto deducted. Practically, auto deduct results very frequently in employee claims, either that they make themselves through an attorney or a complaint to the Department of Labor. And essentially what the employee says is, I had 30 minutes or an hour auto deducted on a daily basis for my lunch break, but I didn't actually get to take all that time. I either got to take less time than the auto deduct, or I had to do some work, or maybe I just didn't get any lunch break that day because we were really busy or there were patient demands or whatever it is. So in my experience, auto deduct really can come back to haunt an employer. And it becomes the employee's word against the employer's. And the employer won't have a record showing that a lunch was taken because you won't have required them to punch out and back in. And again, in my experience, when it is the employee's word against the employer's word, the Department of Labor oftentimes sides with the employee in the absence of any record to the contrary. So that's my little plug against auto deduct.
And I'll just give an example of an audit I handled for a client who used auto deduct, and then they were audited, and the Federal Department of Labor auditor disagreed with the auto deduct, said, okay, we'll count that, but only if I get to come over and interview every one of your employees for the past 2 years, and we'll call up the people who've left, give me their addresses and phone numbers, and get to interview them and have them agree that they always, always, always received that non-working 30 minutes of auto deduct time. And my client employer did not want the Department of Labor to come on in and start interviewing employees, as you might imagine. So they were assessed back pay for the last 2 years for every employee and former employee, and overtime if it put any employees into overtime. So real life example, the Federal Department of Labor on a practical level doesn't like auto deduct either. So Eli, back to you.
All right, thank you. So we just covered meal breaks. Now we'll cover the other main type of break, which is a rest break. Again, under federal law, there's nothing required, but if you do provide a rest break, anything shorter than 20 minutes must just be treated as paid, treated as hours worked. And if it's longer than 20 minutes, and as a practical matter, 30 minutes or longer, you could treat it as unpaid as long as you follow the rules we discussed with regard to meal breaks, meaning completely relieved of all duties, active or inactive. Minnesota has a specific rule about rest breaks. For every 4 consecutive hours worked, an employee needs to receive adequate time to use the nearest convenient restroom. So in practice, this means 5 to 10 minutes, depending on your workplace and the surroundings. And as under federal law, this needs to be paid since it's going to be shorter than 20 minutes. So I think that covers breaks, and we'll move on to our next topic, which is timekeeping. These timekeeping rules apply only for your non-exempt employees. For the most parts, that's going to be hourly employees, but an important thing to remember is that if you have any non-exempt employees who you choose to pay a salary for any reason, which you're allowed to do, you still need to keep track of their time and follow the rules that we're about to cover. The general requirement for timekeeping is that an employee you need to have a record that shows daily and weekly hours worked for all of your non-exempt employees. It's not specifically required that you actually show hour in, start of a lunch break, end of a lunch break, and hour out, but it's absolutely a best practice to have that much detail in your time records. When it comes time to face an audit, it's going to look much more organized and persuasive if you have a detailed time record showing the time in and time out, as opposed to a handwritten note that says Monday, July 31st, 8 hours, and that's all you have. So we strongly recommend finding a system that works. On that point, finding a system that works, there's nothing specifically required. As long as you end up with accurate and complete records, you can use whatever system works for you. This might mean that you have employees punch a clock, but you don't have to do that. You can have employees maintain their own records by hand or electronically. You can assign an employee to serve as timekeeper for a group of employees, or you can find another method that works for you, as long as you end up with accurate, complete records. An important pitfall to cover is that non-exempt employees, particularly in the electronic age where a lot of non-exempt employees have Blackberries or are logging on off hours, those hours all count, even if it's just answering an email or responding to text messages or taking a call. Your non-exempt employees need to keep track of all those hours and include them in their daily and weekly hours worked. So the best practices that we would suggest there are that first you distribute a policy to all of your non-exempt employees, making sure they know that all of their hours worked, even small periods of time outside of business hours, need to be tracked. We also recommend that you have employees on their time cards verify that the time records show all of that their time has been included. That verification will come in very handy if an employee down the road comes in and says, "Oh, but I worked all this evening time that I haven't been paid for." And then a final point is that you as an employer, you are allowed to prohibit work outside of normal work hours if you don't want to deal with paying for these little chunks of time or potentially paying overtime for these hours. You can have a rule prohibiting it, but if an employee breaks that rule, the employee needs to be paid for the time that they worked. You could discipline the employee for breaking the rule, but you can't not pay for the time worked. So with that, I will pass it back over to Mary.
Okay, thanks, Eli. All helpful info. And a question came in real quickly. Ingrid, do you want to take that one?
Yes, so I have a question here. It is, do we have to make employees take an unpaid meal break during a busy day when it would be best if they did not take one because of the busyness of our business and our flow of business that day? So under Minnesota law, under Minnesota's meal break law, yes, you have to provide the meal break, whether it's good for your business or not. So if you want to be legally compliant, you would make sure that all of your non-exempt employees in Minnesota who are scheduled to work 8 or more hours truly get that 30-minute meal break. Again, regardless of what's going on at work that day. To do otherwise, and either have them work a really short, take a really short meal break, or to not take a meal break at all, is going to be non-compliant with Minnesota law and result in some risk that the employee is going to complain. And I will tell you, practically speaking, having non-exempt employees skip or shorten their meal break is a fairly regular practice, particularly when the workload is heavy. But in our experience, employees, even who may say to you that they're just fine with it that day or that month or even over time, can change their tune on that at a later date if they become disgruntled. And again, even if they told you, nope, I'm just fine with this, no big deal, I'll have a working lunch, I'll work through my lunch, I'll skip my lunch, does not give you any protection at a later date if that employee makes a claim. I don't know, Mary or Eli, if you have anything to add.
My only thought, I totally agree with what you just said, Ingrid. I totally agree, except I have been told that on occasion, if it's a rarity, it can't be even like once a week, every week kind of thing, but if it would happen once in a blue moon, so to speak, that the employee could not take that break for the meal, or was just allowed to kind of eat on the run, so to speak, you'll probably be okay. But you don't want to make that a practice. And the problem with that eating on the run, that works for some kinds of employees, but it certainly doesn't work for all employees. Anybody in a healthcare setting, that doesn't work. You can't be eating in front of the patients or in lab areas or anything like that. Some manufacturing clients have clean rooms. It just all depends. Or you don't want them eating around the equipment of any kind. So that would be a rarity. But I totally agree that, yep, you need employees to take their meal break if they're working 8 or more hours here in Minnesota. That's the rule. And there are other rules in other states, so be sure to always check those. Okay, and here's another quick question that came in. If non-exempt employees clock in and out, how does the employer prove they acknowledge time is accurate? Seems to be a burden to print or sign time cards. Well, my encouragement would be try to automate it as much as you can. They don't have to physically sign, but there needs to be some kind of checkbox or something that employees have to overtly check to say my time is accurate. I agree that I have recorded all of my time for the work week. Particularly these days, I think a lot of clients use computer-based time records, and then they're checking the box that it's accurate and complete before they then submit it to payroll. So hopefully it's not a big burden, but that depends on the methodology that the company uses for the time record. Other thoughts?
No, I agree. Hopefully the timekeeping system, the software program is sophisticated enough to have that kind of built in to the system. I have seen on paper time cards, I've also seen just a built-in to the template language that says, by submitting this time record, I am acknowledging it's complete and truthful and accurate, and it's just a part of the template, and that language appears on every single time card that's ultimately turned in.
Correct. Yeah. Okay, well, let's try to do a little bit of travel time, and we'll buzz through this pretty quickly, but do keep your questions coming. Travel time pay is only for non-exempt employees, of course. Exempt employees, that travel is all part of their regular salary, and that was one of the questions that we thought might drive some employers to try to keep employees under the new regs that were going to have the higher salary as exempt, because they had exempt duties. Maybe they just needed a slight increase to be at the salary that was going to apply, but now, at least for now, does not. So travel time pay, just quickly, a couple of the rules. Home to work obviously is unpaid no matter how long you sit in that freeway traffic. Home to work in an emergency, well, that likely will need to be paid, but it's a factual analysis that we'd have to look at. Now, if you require people to drive from home to work on special assignment in a different city or farther away, the rule is you're supposed to pay for the extra travel time for that particular day. Of course, travel during the workday has to be paid if they go from site 1 to site 2 for you. The time traveling between sites, that's paid. And then there's a whole bunch of rules about overnight travel for non-exempt employees, and it comes down to you must pay for travel during the regular work hours all 7 days, but you can pay more. So if their regular time is 8 to 5 and they're traveling on Saturday between 8 and 5, they get paid for that time. But if they're traveling at 6 a.m. to 8 a.m., technically the federal law and Minnesota law doesn't require you to pay for that 6 a.m. to 8 a.m. travel time for your non-exempt person, because that's not their regular work hours. But I think that's kind of silly, and I think your employees are going to think that's kind of silly too, but it's not required. You can pay, but you don't have to if it's outside their regular work hours.
We have a travel time question here, so do you want to take it in real time?
We'll do that.
Okay.
When a non-exempt employee travels over the weekend for a conference, what would be the best way to pay them for their time at the conference? By paying them a set 8-hour per day at the conference, would that be enough? Well, depends, because if you go to my next slide, work during travel always has to be paid. So if they go to a conference on the weekend and they are at the conference during their regular scheduled hours of work, so again, let's use 8 to 5 with a 1-hour unpaid lunch, because they're not doing any work during that 1-hour unpaid lunch, then they would get paid from 8 to noon, let's say, and then they take their 1-hour non-working lunch, and then they start again at 1 to 5. So they're going to get paid for 8 hours. But let's just say instead that lunch, that's not non-working. They are supposed to be talking to colleagues and making work connections, et cetera, et cetera. Okay, so now that lunch, that's a working lunch, and they have to get paid. So now they're going to get 9 hours of pay. And maybe in the evening, this conference even has another kind of cocktail hour or something like that, and the employees are expected to be there, again, making connections. So now that's work time. So it's a factual review, but you pay them for all work time, and you pay them for attending the conference during the regular scheduled hours.
I have a couple more questions that came in, so I just want to see if I can cover these in the next minute.
Okay.
So the first one, can an employee sign a waiver on mealtime that they will eat at their desk but regularly don't want to take a meal break away from their desk? So under Minnesota law, no. A waiver of this sort would be unenforceable and ineffective. And that just kind of is what it is. The next question, and I think we addressed this a bit, we have been trying to push employee approval on their time cards, but there are many that don't approve or acknowledge it at all. What should we do in that case? Well, I think it's a matter of deciding, is this a requirement that employees approve and acknowledge their time card, which we've just said we think is a good practice? And if they're refusing to do so, I would have a conversation with them and try to understand that. If ultimately they're just being disobedient, for lack of a better word, and cannot articulate a legitimate reason for their refusal, I think I'd say to them, hey, listen, this is how we do things here. You either do this and approve and acknowledge your time card, as do all other non-exempt employees, or if you refuse to do so, you can't work here.
Very good. Okay, I'm going to take another 30 seconds and try to just run through the rest of this. Training time, mostly paid. You've got to meet all the listed items not to pay it. There's this one exception, but it's pretty minor. Deductions and minimum wage, be careful if you make deductions against pay that you never reduce a non-exempt person below minimum wage per hour worked. Comp time, you can't do that for non-exempt employees. That's the whole point of overtime. Only the state and federal governments can do that. Exempt employees can do comp time, but never take away from their salary for comp time. And be careful about paying overtime on non-discretionary bonuses. I've seen way too many clients get caught in this trap, and then they owe back overtime because they did not pay overtime retroactively on a bonus that was not discretionary. And there's some ways to avoid that problem, as I have here, and then a methodology for how you do it. And then finally, if you have employees on that do on-call, be careful about that. This used to only apply to medical places, but now it applies to almost every employer because they have IT people on call. And if you pay for on-call time, whether it's working or non-working, and that's a key inquiry to decide, but you always have to pay overtime on that on-call pay, and I've given you the methodology for including it in the calculation. Quick housekeeping, we did questions. We just want to let you know that this program has been approved for HRCI and SHRM credit, also for Iowa CLE, and we're pending on Minnesota CLE credit, and we will send out that credit info to all the attendees in a separate email. And we've got one more quick question.
Okay, what about attendance at a holiday party for a non-exempt employee? It's not required, but it's encouraged. What if they talk about work at the holiday party? This is a great question. So if attendance is not required, but they choose to attend, I don't think you have to pay them for their time at the holiday party. Practically speaking, if they talk a little bit about work at the holiday party because it just comes up in conversation, again, I don't think you have to pay them for any part of the holiday party. If there is a part of the holiday party that is designated for a work-related talk or topic, or a working lunch or that type of thing, then I do think you'd have to pay them for the really obvious kind of work-required piece. But generally speaking, no pay required for your hourly employees at the voluntary holiday party.
Agreed. Okay, we need to end here. Please do check our website, fredlaw.com/events, for additional webinars coming up in the near future. Otherwise, thank you so much for participating today, and we hope you have a wonderful day and week. Thank you.